Morning, Your Honors. Lawrence Klepetko from Sarasota, appearing on behalf of the appellant Chaba Bokros. Could I ask the court to notify me at about 10 minutes of time to reserve?
I'll let you know. That's a long reservation, but I'll let you know when you get there.
Well, okay. I may go over that and just leave a few minutes once I get notified. Thank you, Your Honor. By way of introduction, I'd like to speak to several different issues in my argument. One would pertain to non-verification of the plaintiff's complaint, problems with evidence in the trial, including fraud on the court, and a general impression of unfairness to the defendant at trial with the trial judge's actions at the trial. By use of the term fraud, I mean use of the court's process with documents that appear to be regular on their face, but in fact, with some extrinsic evidence, are not so. Let me start with the trial court's handling of the note and mortgage as evidence. I think it's important for this appeal for the court to recognize that no original note and mortgage was ever presented at trial for purposes of foreclosure on the note and mortgage.
Note and mortgage were filed of record, though, correct?
Filed of record. Your Honor, thank you for that question. That is part of the point that I particularly want to address. It was first, it's never authenticated, okay? What you have is something that was filed with the court clerk by the plaintiff's counsel indicating that it was the original note and mortgage. I particularly point that out because the indication of original note and mortgage on a notice of filing is not authentication.
I thought that was admitted in the pleadings. The execution of the note and mortgage were admitted in the responsive pleading.
That is confused, Judge Black. I did not draft that answer to the plaintiff's complaint, but I have to live with it on this argument today.
What's confused about it?
There are two paragraphs that deal with the note and mortgage, and from memory they are 2 and 3. Paragraph 2 denies the original note and mortgage. Paragraph 3 contains a denial but a gratuitous remark that the defendant did execute a note and mortgage to the original lender. If you read those allegations and those pleadings carefully, I think you will not find that there is an admission by the defendant of the specific documents being the original note and mortgage. But that's a very good point that I want to bring out. There's another point that I think for purposes of this appeal that the plaintiff relied substantially, notwithstanding authentication of an original note and mortgage, of claimed certified copies. There were never any certified copies offered at the trial. There were several copies of documents floated around, talked about with reference to the note and mortgage. But again, at the end of the day, there was never presented at trial an original note and mortgage to be authenticated by a proper witness at trial.
Was there an objection to the copies that were tendered on that basis?
I would answer this way in response, Your Honor. There was a great deal of controversy offered in behalf of the defendant regarding the original note and mortgage. And I would emphasize that prior to the trial, there was an effort diligently made by the defendant to have these documents brought up from the court clerk's office so that they would be available for trial. All of this bears on the Florida Evidence Code regarding handling of original documents at trial. And bluntly, the requirements of the Florida Evidence Code regarding original documents were not followed. That is a big part of this appeal. Let me read something from the rehearing order that sets the tone on behalf of the trial judge regarding handling of an original note and mortgage properly as evidence. First, before I get to this language, in the trial transcript is the trial judge's inaccurate reflection that these documents aren't even filed anymore at the court clerk's office. That's simply wrong. It is contrary to a local rule for the 12th Judicial Circuit that requires this. For whatever it's worth, the deputy clerk at the time corrected the trial judge, but the trial judge went ahead. Let me now read from this order. The defendant was noticed on February 22, 2013 that plaintiff had filed the original promissory note, mortgage, and modification with the clerk of the circuit court. Therefore, the defendant could have reviewed the documents at any time leading up to the trial. In addition, a certified copy of each of these documents was admitted at trial. What's wrong with this statement? First and foremost, ignoring the Florida Evidence Code regarding the handling of original documents. I would argue that one of the purposes or one of the conveniences of having them filed with the court clerk is to have them brought up and made available at trial, which Mr. Bokros diligently tried to do and was effectively rebuffed. Second, there is, in essence, out of this statement from the trial judge, some new fabrication or extension of the pretty straightforward Florida rules of evidence regarding original documents, that no, we aren't going to use the original documents. A party has to go down and look at them in the court clerk's office, and it's okay at that point that we would go forward with copies, whether certified or not. And again, the trial judge made a point in this language of indicating that a certified copy was available at trial. Not so. They were just other copies, and they were not certified. And most importantly, they did not follow the Florida Evidence Code for handling of original documents. Let me go to the point of verification of the plaintiff's complaint. Once again, we are faced with an instance of what appears to be regular on the face of the complaint just wasn't so with testimony at trial. What is indicated in the plaintiff's complaint is a sworn statement before a notary public. The testimony at trial indicated no. The plaintiff's representative did not take any oath. It was not sworn to. The requirements for a verification of a plaintiff's complaint simply was not met. And I think for purposes of this appeal, it comes to you. What is the purpose of this new rule requiring verification of a complaint? I'd certainly argue that it's far more than adding a few more lines to a plaintiff's complaint. The Supreme Court intended that this type of document be...
And you're at the 10-minute mark, Mr.
I'll
Copeland.
take a couple of other minutes then, Your Honor, and then reserve the rest of the time. The rule obviously intends that a plaintiff bringing a complaint in mortgage foreclosure read and comprehend and swear to or affirm the truth or absence of what's alleged in the plaintiff's complaint. There were a number of other documents presented at trial that indicated apparent correctness on their face, but were not so. So-called corrective assignments had indications to be presented at trial by the defendant that at the time those corrective documents were made, the indicated entity was not even in existence and recognized by the Florida Department of State. There is one of those documents that was blatantly altered from its original composition with cover-over fluid, whiteout fluid, whatever you want to call it, first recorded in one county, the wrong one, and after modification of a notarized document recorded in Manatee County, Florida. So
If that assignment was void or voidable, if the assignment was void or voidable, would there be anything precluding a corrective assignment from being utilized?
A proper corrective assignment, Judge Silverman, I think could be used. But I say that proper. The entity making the corrective assignment at the time should be an active and recognized entity filed with the Florida Department of State if it's done by an entity. And again, this was simply not the case. Let me reserve the rest of my time if I could. Unless you have other questions that I could.
You've got about 5.5 minutes left.
Thank you, Your Honor.
May it please the court, Roland Waller. I'm the attorney for the appellate Free Son, who is the mortgage holder and prevailing party when asked that you affirm the lower court's decision. I can only comment, I guess they've abandoned the argument about the witnesses or the fraudulent, purported fraudulent mortgage where they added a witness after its execution, so I won't comment on it and don't believe that's
It's raised in the brief, Mr. Waller. I don't think it's abandoned unless he says it's abandoned. So if you've also addressed it in the brief, so whether
absolutely. Well,
choose to argue
basically,
is up to you.
The facts are is that the document was not altered, and so I don't think that the issues that they've taken or what arises from that has anything to doesn't rise to setting aside. Simply, the document itself wasn't altered. It was basically surplusage as far as someone signing as a witness that wasn't there, and that the witness was not required to be there, did not change the import of the or the legal effect of the document, which is a mortgage, which doesn't have to be witnessed. So all the issues arising from that, I don't see are well taken, since it is not an altered document. It simply had an additional witness. I think they raised for the first time today the unfairness of the trial judge, although I don't know that they've set forth any argument as far as that's concerned.
Had there been any motion to disqualify the trial judge?
No, Your Honor. And the issue about the verification, I point out that it is signed, if you read the verification, if we want to address it, but I don't think you reverse a decision or a trial court decision because of a verification on the complaint. That may be something that could have been raised or addressed earlier in the pleadings or whatever, but I don't think it goes to trying the case on its merits. But to go ahead and salute it, it says under penalties of perjury is what he signed it as, and so whether he raised his right hand and swore to it, that's his statement is that he signed it under penalties of perjury. Then addressing the other argument as far as the original promissory note and mortgage, they were specifically admitted in the pleadings, I think, as Judge Black has pointed out on paragraph 3. And so we simply moved them into evidence. They weren't there, but I don't know how. They haven't pointed any prejudice or how that's reversible error to have, if they're filed with the court, well, okay.
Well, the evidentiary rule allows copies to be used absent a challenge as to authenticity, accuracy, and so forth. Was any challenge raised at trial on those bases under the rule?
I don't know that, as counsel argued, that there were objections, although I don't know that they were specific as to authenticity as far as that's concerned. The pleadings basically went to the mortgage and the saying how it was fraudulent, but nothing as far as the promissory note's concerned. The note is self-authenticating under the UCC in any event, and they admitted it, so the only thing we needed to do was to move it into evidence. From what I can see, as far as it's self-authenticated, and they did not raise that he didn't sign the note in the pleadings, which I think he also must do. So I don't know that, so I don't think that objection was raised, although they objected, I think, to just about every document we put into evidence, and the judge basically reserved to allow them to cross-examine. So we proceeded. But the mortgage is also, was self-authenticated too, since it was put recorded in the public records and acknowledged. One issue is, I think the corrective assignments show that we had standing at the time of filing the suit, and that I think it's appropriate that we did file the defective assignments, and that was a result of a prior foreclosure action being dismissed, is because that it didn't look good, so they went back and properly did these assignments. I don't think that the fact that a administratively dissolved corporation or entity can execute administrative documents to cure it, so that doesn't make those documents void. The other thing is even if you do assume that there's no challenge as to the mortgage before it was ever assigned the first time and came back, if you even set all those aside, it was the holder at that time before this fraudulent assignment ever took place. It was initially went to Free Sun, then Free Sun assigned it to Pine Hill, then Pine Hill assigned it back to Free Sun, and so they're challenging the first assignment from Free Sun to Pine Hill. So if all those are out of the way, well, it falls right back to Free Sun anyway, that they had the note and the initial assignment from the original lender. I don't have anything further unless the court has some questions.
Thank you, Mr. Waller.
Thank you.
Mr. Clifton, go.
Judge, there's proper interest in altered documents. Can I emphasize that all of this leads up to proper interpretation of handling original documents under the Florida Evidence Code. And once again, I want to underscore, these documents were indicated by the trial judge to not be available for the trial. The trial went on otherwise. The judge was corrected, if you will review the trial transcript, by the deputy clerk that was there, and particularly with reference to proper handling of original mortgage note documents for a foreclosure trial. The Florida Evidence Code clearly provides they are to be used at trial, not copies. And in any event, as to several copies that were floating around at the time of the trial, none of those were certified. So we have a fundamental interpretation of application of the Florida Evidence Code, and there are provisions in there for challenged documents as to authenticity, which there was at trial, and there is a specific reference also to a negotiable instrument, which the mortgage note obviously is. So from the standpoint,
the evidence code that you're referring to, are you talking about Rule 90.953?
I don't know it by number, Judge.
The one that talks about admissibility of duplicates?
Yes, sir, I believe that's it.
And a duplicate is admissible, and it talks about various things, but item number 2, a genuine question is raised about the authenticity of the original or any other document or writing. So was there an objection under this rule as far as the use of duplicates?
I believe there was. Was it framed as an objection? Yes, I believe when
well,
you
the court
read...
has to be put on notice that there's something suspect about the copy, and item 3, that it's unfair under the circumstance to admit the duplicate. Why was it unfair in light of the admission to the complaint and the tendering of a copy? And my recollection is there wasn't a specific objection that a duplicate would not properly be admissible because it's not an accurate duplicate, for example.
First, my memory is that there was plenty of indication starting with the pleadings about the authenticity of the note and mortgage. And at trial, yes, there was plenty of indication made that the defendant was proceeding on reliance on the Florida Evidence Code. I believe the provision that you have just mentioned, that the originals would be used, including diligence on the part of the defendant to make special arrangements with the court clerk to have the documents filed as purported originals, brought up and made available for use at trial. For whatever it's worth to you, there's a pretty common practice in a lot of these mortgage foreclosure actions that originals are not brought up. The court clerks typically call up on a screen what has been filed for whatever that's worth. Once again, a presentation on a monitor screen is something of a copy which subverts the clear intent of the Florida Evidence Code that you use originals. That occurred in this trial. And unfairness to the defendant under the circumstances started at trial with the trial judge's own unawareness of what went on in his own court, and then followed up by a rehearing provision, which I read to you.
Mr. Kopacko, just to let you know, you've got about 30 seconds left of your reserve time.
Okay. Counsel for the appellee argued about self-authenticating documents. My understanding of that term means that there is something attached to a document that provides for a basis of authentication other than through a witness.
And you need to go ahead and wrap up then. Are you all set?
That would probably be the extent of it, unless you all have any other questions that I might be able to field for you.
Very good. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. The next case is Steele versus Georgia Pacific, which is consolidated with Chubby and Valverde versus Georgia Pacific.